as we initiate chaos. Theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness, only another. It's full steam ahead, full steam ahead. All aboard the Petty Express, misdirected from the start. It's a runaway train, I come a freight train, I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
We are back to the grind, and they are not back from lunch yet, so does look like we might actually be caught up to them by the time that they get back from lunch because they're supposed to be back at 1:30. So we might have actually hit like the sweet spot. It has rarely ever happened.
Gave you the gun, gave you the barrel, the projectile, the bullets, the DNA. We showed you him shutting off his camera. I can't give you any more because he shut off the cameras. We followed the evidence in this case. Murder doesn't make sense, but murder happened. Murder happened November 20th, 2018 in the darkness. And it happened 4 times. There's no way I could justify anything remotely resembling a good reason. But it happened. Talked about timeline, I promise. Just about that. Just want to close the loop with respect to the timeline. Okay, you talked about it, and I think the defense, Mr. Massalone, I think it was with Lieutenant Petrozello, we created a timeline and all that stuff. And I guess the idea was that, like, the timeline doesn't make sense, right? There's not enough time to do this and not enough time to do that. Well, you'll have those timelines and evidence. They've been marked. I think Miss Wallace.
Time keeps on slipping, slipping, slipping. No, I would say into the future, but that's a lie because it feels like we've been stuck in closing forever.
Asked some follow-up questions and we had some things. 3:50 is a phone call. First phone call. 6:05, Keith calls Paul the second time. 1:27 a.m. Paul plugs in his iPhone. Probably just after practicing with the laser light in that other 6 hour. 1:28 goes into the garage, shuts off his camera. We see the Cayenne, see what we would have seen. 1:31, he goes downstairs. Sorry. We see him here, right? And we see the gun locker. He's shutting off the cameras downstairs, making sure that you wouldn't be able to see him, leaving the DNA and putting the gun back, swapping the barrel, et cetera, et cetera. And we get to the Porsche, clearly, the Porsche Macan 207, leaving Tilton. 227, Porsche Macan, Willowbrook. 235, 251, the video we saw with the gloves and the hair. 252, the first alert from the Verizon, saying basically the Verizon box not cut yet, but saying that power's cut to the area. Same way that camera, the Nest camera outside said 252, right? Keith sends these text messages 3:14 through 3:18. There's 4, but the last one says, really, it's not really communication. It's a text message, but essentially, if you want to look at that as communication, that right here is the last thing that Keith Caneiro would ever say. And it's basically telling his brother he's going outside to check on the generator. Little did he know that when he got outside to check the generator, these and this, we're going to end his life. We know the Verizon line cuts at 3:42 per what they said. So there was also some testimony. I'm not going to belabor it. Just 6 minutes. There's no question it's enough time. But it could have actually been a little bit before 3:42. I think Mike Abraham said that Verizon pings the box every once in a while, at least every 30 seconds. So I mean, it could have been 30 seconds earlier. Who knows if that's even accurate, if it registers right away. But the line's cut, the fire's set, and then he runs. Like, look at the pictures. I mean, I skip the nearest bathroom and I go to the next bathroom. That's probably the distance of me running to get to that car, to get onto Willowbrook at 3:48 and 17 seconds. And then ultimately 4:08, Porsche Macan returns to Tilton. Paul's iPhone is unplugged, 4:54. The main fire starts at 4:57. Porsche Cayenne pulls out 27:50. Wanted to. I think I skipped. If I could for 1 second. Apologize. Almost done. Just gonna go my one slide. We'll take you back for 1 second. Just camera 5. This is when the garage where the car pulls out. Then we have that garage fire. Can we shut off all the lights? So we know the car pulls out. Mr. Caneiro pulls the Cayenne out. About 5 o'clock. Just fast forward because we know we got about a minute and a half until that fire starts. We're gonna let it run now. About 5:51. And just when I talked earlier, this is that light by the garage. One of like the sconces or wall-mounted lights to the garage. Just in the next little while, just want you to pay a little attention to some movement, some shadows in this area before the flash. Now, we said that the people that were alleged to have been there at 4:30 wouldn't have still been there at 5:02, so you can't really make both arguments. But what we see here is about a minute and 20 seconds, minute and 30 seconds after Mr. Caneiro pulls the Cayenne out. It's been suggested that like someone else had to be there to set that fire. Now, I'd suggest to you that when you look at that, it's impossible to say that there wasn't someone there, i.e. Mr. Caneiro, who came out of the car and went back up there. It would have been as simple as we said, like his family gets in the car, but like the wife went back inside, his daughter was calling 911, I don't know exactly when she got in the car. They all got in the car, there's no doubt about that. But like, what if he just pulls the car out into the street? And then whether the family's there yet or not, if they are, I forgot to shut the garage door. Boom, towards the freaking car. Because that's the car that you just used to kill everybody. Like, obviously, again, kind of a failed attempt at doing any damage to that car, but like, he either set that fire right before he pulled the car out and it just took a minute, or he went back up. I mean, that fire's not started. Because if you're talking about like someone else being there, Corey, whatever, yeah, if he's not there, he's sitting in the street. It's not like he's not there to see what happened. Like, that fire, ladies and gentlemen, is just another fire set by Mr. Caneiro. It's just another part of the entirety of this case. Okay? That video is obviously not clear enough to say conclusively, but I suggest that you see some movement in that area around that light and some shadows, and it just is not something that proves anything like someone else was there. No one told you that anyone was there. Paul Caneiro, ladies and gentlemen. Paul Caneiro. All of the evidence in this case, all of the ballistics, the DNA, their ammunition, hiding of the backpack, hiding of the barrel, they're all shutting off the cameras. They're all just ways to try to hide the evidence. The evidence that shows that he, and he alone, committed these crimes. You have video of him shutting off his cameras. You have video of him leaving at 2:07 and returning at 4:08. You have evidence to suggest that is certainly him outside of his brother's house. He had the barrel, the projectiles and the bullets from the scene matched the barrel that he separated from the gun and the gun.
Tammy, you haven't missed much. That being said, I think we are getting closer than we have been to the end. And they are supposed to be coming back from lunch here about now-ish. So we have about a few more minutes and then we should be getting right back to lunch. So we actually haven't missed much of anything. And it's mostly tying up loose ends, mostly explaining again any of the uh, time gaps issues, things like that, that the defense have brought up. So kind of more of the same.
Sometimes, ladies and gentlemen, sometimes the evidence doesn't lie. Sometimes, no matter how hard you try to explain it away or give alternative theories to why his DNA or his wife's, his niece's DNA is in the basement, and why someone would try to frame it, but swap out the barrel, he's not the unluckiest man in the world, ladies and gentlemen. He's just guilty. He's just guilty. And that's simple. And one last thing I just really wanted to say, and the judge is going to read the law to you very shortly. He's the one who controls how you consider the facts of this case in relation to the law. And ultimately, he's going to give you, when you deliberate, you're going to get a verdict sheet. And this is just some questions that you're going to have to answer based upon all the time you spent here, all the attention you paid, the arguments of counsel, but most importantly, the evidence from the stand, the physical evidence. And you're going to have to answer some questions that go a little something like this. I'm not going to read the whole thing, I promise. You're going to have to determine if the defendant is guilty of murder. Did he purposely or knowingly cause the death of Keith Caneiro, for instance, or serious bodily injury resulting in death? Okay? That's the determination you need to make with respect to each victim. Then you're going to get some other questions on some of them, kind of like, did he do it by his own hand? Meaning, did he do it? Okay. And then there's some other questions like, did he do it for money or with the children? You know, were they under the age of 14? You're going to answer some of these questions once you find him guilty of murder. And you're going to get some weapons charges. You're going to get the theft. You're going to get the misappropriation. The one thing is, with respect, so you understand, with respect to felony murder. Now, with felony murder, you just get Jesse and Sophia. I just wanted you to understand that when we talk about felony murder, we talk about causing the death of the victim while in the course of committing a felony. Here, it's charged with the arson. And the reason why you have Sophia and Jesse and not Jennifer and Keith is because of that very fact that we know, based upon the testimony of Dr. Toma and Dr. Zhang, that like Sophia and Jesse were alive after the.
I like this explanation because I think as a layperson, like most of the jury is going to be, they are probably wondering, you know, why are the charges different? And they've probably wondered that the entire trial. And now when it's all together, I'm sure it makes much more sense than had the state tried to break this down at the beginning in opening statements. So I do like this. I do like that it's not, you know, death by PowerPoint. So again, stylistically, he might not be your cup of tea. For me, I find him to be very good. But if you're more of a, you know, standing still, reading from a very well crafted speech, then he might not be your cup of tea.
Fire was set. So they were killed in the course of him setting fire to the house. Now, they're also victims of murder because they were purposely or knowingly killed by Mr. Caneiro. But I wanted you to understand that is really what we're talking about and why you just see them there as opposed to Keith, their father, and Jennifer, their mother. Ladies and gentlemen, I know that this is an emotional process. Just on behalf of Ms. Wallace, just want you to know that we appreciate the time that you've all devoted to this. I'm sure the defense does too. I'm not trying to grandstand here, but we do appreciate the time, the attention, how you showed up. Sorry if there were delays at times. It could have been our fault. Who knows? But when we talk about justice and we talk about things like reasonable doubt and presumption of innocence and things like that, just remember that like we get held to a very high standard, and that's the way it should be. Okay, we're the state. We have to prove, we have to convince you that this man committed murders, felony murder, weapons charge. We have to do it beyond a reasonable doubt. And that reasonable word is just kind of important because we have proven it to you beyond a reasonable doubt. The DNA, the ballistics, cameras, all the other testimony, all the little things, like showing you he wasn't set up, showing you that that was just another way to try to deceive. I would argue to you that the evidence will not deceive you. It will take you to a place where you will go back into that room and you will decide amongst yourselves that this man, contrary to a lot of things you may have heard about him, this man, on November 20th, 2018, Colts Neck, New Jersey, killed his brother, sister-in-law, 11-year-old nephew, and his 8-year-old niece. Ladies and gentlemen, for one final time, we appreciate your time. The only just verdict in this case, the only one that follows the evidence, is that Mr. Caneiro is guilty of all these crimes. Thank you.
Okay, ladies and gentlemen, it's been a long morning.
Okay, so they went, excuse me, sorry. The one time I'm unmic or unmute myself. So they did go to lunch, and now we're going to come back and listen to the jury instructions. Normally, I F on off during this, but I do worry that this is I maybe I'm not giving the defense enough credit because there were several people that thought that the defense did a really good job. I again don't know how, but I just don't see there being any dissension when they do the first straw vote, like, before when they first get in there, because I think somewhere in the jury instructions, or at least in mine, was, the advice to, if you're unsure how to proceed in deliberations, uh, one idea is to take a straw vote at the beginning, and then, figure out where you agree and disagree, and, write down those points and discuss those points, based on and weigh the evidence and how to, answer those. So I just I don't see how 12 people out of 16 people randomly chosen, anyone would be like, "I'm on the fence." So I don't know, juries are, wild animals, people are all different. I Look, I'm trying to be kind, but I just can't see how you can have a functional frontal cortex and think that the fence did anything for this man. But there you go. They walk among us, and there you are. No, probably not, but sounds like a awesome possum stream to look at later. Yeah, and the victim blaming was, I think, just gross. Yeah, Mustang, I was shocked that there was more than one person, calling out the judge for being mean. Again, I think these are people that have never understood that wisdom is gained by admitting that you don't know things. You don't start awesome and end up awesomer. That's not how real growth works. I know that we have bastardized the hero's journey, to the point of, well, it basically being stupid, but you grow through failure. Failure isn't a bad word, and not in a poster way. Yeah, it sucks all the ball sack. It is not fun. Again, to be, told by life and reality that you are not smart, you are not in control. But there are things that you could do better if you are humble, if you ask people that are smarter than you. I just ugh. Of course, I'm not egotistical about anything except for, like, my intelligence, but I fully admit there are things I suck at. Like, I would have never caught that Paul misspelled assurant. Howdy, howdy. Or assurance. He would have kept on, stealing from me. So because I'd have been like, "Yeah, maybe they're just dyslexic." I will say that this judge has been mostly punctual, and again, I think we're gonna get various things. I do realize that this particular closing has just been forever and 12 days. We are so now the judge is going to give, the jury instructions, kind of what the law is, how the law applies to this case, how they are supposed to interpret the law and the evidence, what they're not supposed to do with the evidence, all that kind of jazz. Now, normally, I I don't stay and watch this, but if there was any case in all the cases I've covered where we could possibly be looking at a very, very quick turnaround as far as verdict, it would be this case. I honestly and I'll put up a poll at the end, but I don't see us going past 5 o'clock, depending on how long this takes. Now, there are 4 different homicides, different levels of homicides, and, different arsons and things like that. So there are a lot of charges. I think there are 9 counts. So we do have a lot of instructions, but and again, I don't ever try to speculate, so well, I'm sorry, Tree 9T. We can only hope. I mean, unless Paul and I hesitate to say this, but unless there was infiltration of the jury, I don't see it taking super duper long. And I don't see someone with all that they've seen with because here's the thing, someone can, do a lot of things for money, but when you are surrounded by 11 people who are showing you, autopsy photos saying, "Okay, so you're okay with letting this. You're okay with this. You aren't sure that he did this." It's really hard to hold that, uh, with that amount of social pressure. I mean, it's possible, but most people break. Most people, would rather go with the crowd, not be singled out, for ridicule or scorn, not deal with people not liking them. We are a social species, so I don't see anyone, even if, let's say, for, speculation's case, uh, since this is all a setup according to Paul, let's steel man that and say that someone, is there and they are, going to say guilty, but we change the defendant. We change the defendant to Corey, because, it works in the reverse too. If we had all this evidence against Paul and this was a case against Corey, and you only had 1 juror that was gonna vote guilty still, I again, it is incredibly hard in an isolated area where you don't have any backup. This is now a social bubble, and you are facing ridicule, scorn, because some people are not opposed to confrontation, and you'd have to be ready for that. You'd have to be ready for people that are very good on their feet, very quick-witted, have a good grasp of the information. You would have to be worried about people like me who would make you logic it out because and I'm not confrontational, which is probably even more dangerous. I just say, "Okay, I disagree. Could you tell me how you get there?" And usually that's more frustrating because if you dig down, there's nothing they can base it on, and then they end up looking like jackasses. And all you've done is ask them simple, logical questions. You're not being a butthead. What in the world? I mean, it's the price we pay to keep it well, okay, here's my 2 cents on the whole thing. Logically, I think that having a sort of lay juror class like they do in Denmark, like Baker does, would be the best of all worlds. There would be continuity, there would be an understanding that while they're a layperson, they're not going to get confused or bogged down or maybe sidetracked, by court procedure that is mystifying to them. Uh, it will make that person, more liable to, you know, sift through the wheat and the chaff, but there are other problems, if you get a dud, you're stuck with a dud for a while. How do you know that a person isn't going to bring politics into this or, there isn't a hot button topic that, despite their best efforts, they're not gonna be unbiased about? Are they going to be honest about that? It would have to be such a rigorous background check to even implement that a randomized sampling of people who would rather not be picked is almost better too. You can make arguments both ways. I think a random hybridization and the choice between might be an option, but would that be feasible? Is it financially relevant? I don't know. That's where I look, I can have ideas. Possibly, depends on how long it takes. We have had, I don't know, 84 years of closing arguments? I don't know anymore. Oh, for the love of Cheetos. No one wants to see Judge Kent, like, buffing his glass oh, good lord, Kim Kardashian. No. Are we gonna be able to hear this?
Hey, ladies and gentlemen, we've come to that point where we've heard all of the summations. You're now going to hear the law from me. The first thing I'm going to do is I'm going to tell you that I'm going to violate every rule of public speaking right now because I'm going to read. So I apologize to you for that. The second thing I'm going to apologize for is that I'm going to change my glasses because these glasses are better for me to see and look at you at the same time. I'm not trying to look different. But
He's Mr. Bifocals. He's Mr. Trifocals. He's Mr. Astigmatism. He used to be farsighted, but he's now old. I can't remember what, the medical name for nearsighted is.
You can tell me if I look smarter. Here, let's see.
Nope.
No, it's still the same. It's the same. All right.
Shots fired.
All right. Ladies and gentlemen of the jury, the evidence in this case has been presented and the attorneys have completed their summations. We now arrive at the time when you, as jurors, are to perform your final function in this case. At the outset, let me express my thanks and appreciations to you for your attention to this case. I would like to commend the counsel for their professional manner in which they have.
Okay, can I speak for everyone that gets sentenced to jury duty? And I mean and I say this as a political effing nerd who was, like, doing a secret happy dance that I got picked for jury duty, and it was a stupid case and not a kid case. So, I say this as a political nerd, but as an inside cat, and let's be real, courts, the only people that are gonna be excited about jury duty are inside cats and olds, okay? So play to your audience that when you want functional people, and I speak for myself, but I think I speak for every, inside cat, inside cattian soul, that you can thank us in an email. Could we just get to the point? I would rather don't thank me for my time, let's get to the point. Give me a card or like a gift card or a free Frosty at the end of this. That I don't want your thanks. Now, again, I may not be the most people-y person, so maybe people do like to hear "We thank you and appreciate you for your time." I'd just rather get the hell out of there and be done. So, as I said, not the best at social cues or niceties.
Presented their respective cases and for their courtesy to the court and jury during the course of the trial. Before you retire to deliberate and reach your verdict, it is my obligation to instruct you as to the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply in a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about the portions of the Criminal Code of New Jersey that must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply this law for this case as I give it to you in this charge. Any ideas you have of what the law is, or what the law should be, or any statements made by the attorneys as to what the law may be, must be disregarded by you if it's not consistent with my charge here today. Now, beginning with the general principles of law that apply to a criminal case, the defendant Paul Caneiro stands before you on an indictment returned by the grand jury, charging him with 4 counts of murder, 2 counts of felony murder, 2 counts of aggravated arson, 2 counts of possession of a weapon for unlawful purpose, 1 count of unlawful possession of a weapon, 1 count of theft of movable property, 1 count of misapplication of entrusted property, and 2 counts of hindering apprehension of oneself. The indictment is not evidence of the defendant's guilt on these charges. An indictment is a step in the procedure to bring this matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty of these charges. The defendant has pled not guilty to these charges. The defendant on trial is presumed to be innocent, and unless and until each and every essential element of the offense charge is proven beyond a reasonable doubt, the defendant must be found not guilty of that charge. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to his innocence. I should stop right there for a minute. As you've heard, a defendant does not have to talk to the police at all. If he does decide to talk to the police, he can. But if he doesn't, you cannot hold it against him in any regard. Understand?
Yes.
All right. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant's guilt beyond a reasonable doubt. You've heard the attorneys talk about what reasonable doubt means. I'm going to tell you what it means right now. Some of you have served as jurors in civil cases. where you are told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt, for example, leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. It is not the state's job to prove this case beyond any and all possible doubt. If you are firmly convinced of the defendant's guilt on a particular charge, you would find him guilty of that charge. If you are not firmly convinced of the defendant's guilt as it relates to a particular charge, you would find him not guilty. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during trial and to instruct the jury as to the law which applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of the evidence, either in or outside of your presence. These rulings involved questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it is not an expression or an opinion by me on the merits of the case. Neither should my other rulings on any other aspect of the trial should be taken as favoring one side or the other. Each matter was decided on its own merits. During the course of this trial, there were numerous occasions during which the court conferred with attorneys at sidebar. These conversations are a normal and necessary part of trials and are designed to address various legal, procedural, and evidential issues that arise during the trial. You must not speculate about the subject matter of any sidebar conference, nor should you draw any inference or conclusion from the fact that sidebar occurred. Neither should my rulings that result from these conferences be taken as favoring one side or another. Additionally, you must not consider or evaluate the communication between the court and the attorneys during sidebar conferences for any purpose. Judicial dialogue during legal discussions are not evidence and are not an indication of how the court views the attorney.
But they're flippin' flapjack entertaining, and jury, you're missing out. In fact, look, if you're not traumatized as hell, and look, I get the feeling you probably never want to see this again, but honest to God, watch the judge ream her. And yeah, it's not as fun. It's not in the way it hubbly sounds. There is no washing machine involved, but there is an entitled princess getting told reality is real. So if that's the kind of thing that, makes you giggle, I would encourage you to watch that. After you make a verdict and all that. And if you're part of the jury, why are you watching me right now? Look, I understand that you had to sit there through these closings without anything. God bless you. God bless you all. I'll pray for you. I'm gonna light a candle for you, okay?
The facts of the case, the credibility of the witness or witnesses, or the guilt or innocence of the defendant. It is also important to note that attorneys in this case are tasked with providing zealous advocacy, which includes raising objections, making legal arguments, and addressing issues at sidebar. I may have sustained objections to some questions asked by counsel, which may have contained statements of certain facts. The mere fact that an attorney asks a question and inserts facts or comments or opinions in that question in no way proves the existence of that fact or facts. You will only consider such facts which, in your judgment, has been proven by the testimony of the witnesses or from the exhibits admitted into evidence by the court. The fact that I may have asked questions of a witness in a case must not influence you in any way in your deliberations. The fact that I asked such questions does not indicate that I hold any opinion one way or another as to the testimony given by the witness. Any remarks made by me to counsel or counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. As I instructed you in the beginning, I indicated that you are the judges of the facts. And as the judges of the facts, you are to determine the credibility of the various.
So there are 4 charges of homicide, but the homicide charges of the children are considered felony homicide or Most states would call it first degree. The aggravating factor being that the children were still alive and unfortunately lost their lives due to carbon monoxide, as well as their injuries. There is also the 2 arsons. There's the, tampering with evidence. I believe there's, the larceny or the theft from the trust. So I think there are 8 or 9 charges, but that's basically how it's breaking down. Now, if he gets found guilty on all of these, he will the most he's facing is life without, the possibility of parole.
Witnesses, as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said, or I may say, recalling the evidence in this case, it is your recollection that controls as it relates to the evidence and how you're going to apply such evidence. Arguments, statements, remarks, openings, and summations of counsel are not evidence and must not be treated as evidence. Although the attorneys may have pointed out what they feel was important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. You saw 2 PowerPoints during the course of the summations. I just want to remind you, there was testimony that was relayed in those PowerPoint slides. It is for you to decide if that information that was supplied to you on those PowerPoint slides reconciles with your recollection of what the testimony was. If for some reason that when you were reading it on the screen for either side and you decide that's not the way I remember it, it's the way you remember it that matters. It's not the way that you saw it on a particular screen. Whether it's spoken on a screen, or noted on a screen or spoken in words, always it's your recollection that controls when we deal with the evidence. It is your sworn duty to arrive at a just conclusion after considering all the evidence which was presented during the course of the trial. Now I will move on to part 2 of the instructions and discuss the evidence that you may consider in judging the facts of the case. When I use the term evidence, I mean the testimony you have heard and seen from this witness box right there, any stipulations and the exhibits that may have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only the items that were marked into evidence can be given to you. If you remember, we had this discussion a day or 2 ago. You can always remember the testimony about an exhibit, but if you don't have it, I promise you, we gave you everything you're supposed to have. If you don't have it, you can only rely on the testimony about that exhibit. You are instructed that certain photographs have been admitted into evidence as exhibits for both the state and the defense. The duplication of any photograph does not increase or decrease its evidential value. You must not give a greater or lesser weight to any exhibit because it appears more than once. All evidence is to be considered and evaluated by you under the same standards. Any testimony that I may have had the occasion to strike is not evidence and shall not enter into your final deliberations. Remember the number 2 pencil with the eraser on it. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave you a limiting instruction on how to use certain evidence, that evidence must be considered by you for that purpose only. You cannot use it for any other purpose. As jurors, it is your duty to weigh the evidence calmly, without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state of New Jersey and the defendant of what you promised them: a fair and impartial trial by fair and impartial jurors. Also,
This is not me. I guess the feed died?
on the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide using your own common sense, knowledge, and everyday experience. Ask yourselves, is it more probable, logical, and reasonable? We don't ask you when you come in here and be jurors for this case, we do not ask you to leave your common sense at the door. We want you to bring it in. We want you to use it as a part of your deliberations. It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct and circumstantial evidence. All are acceptable as a means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct and circumstantial evidence, provided, of course, that it convinces you of the defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, or a combination of the two, or a lack of evidence, if it raises in your mind a reasonable doubt as to the defendant's guilt. The parties have agreed to certain facts. The jury should treat these facts as undisputed, meaning that the parties agree that these facts are true. As with all evidence, undisputed facts can be accepted or rejected by the jury in reaching a verdict. The stipulated facts are as follows. During the testimony of Lieutenant Petrozzillo, you heard on January 27, 2019, a recorded phone call during which Paul Caneiro and his wife, Susan Caneiro, discussed whether Susan can use her existing power of attorney to access the TD Bank trust account. It should be clarified that the parties stipulate that prior to this call, on December 3rd, 2018, Paul Caneiro resigned as trustee of the Keith Caneiro Irrevocable Trust and did so via Susan's power of attorney. As a result, the role of trustee was transferred to Corey Caneiro. Second stipulated fact is that Jesse Caneiro had an iPad. The parties agree that Jesse Caneiro's iPad was never seized or searched by the police. Now, as the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the following: the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment and understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the state for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony of the witness has given, whether the witness made an inconsistent or contradictory statement, and any and all other matters in which the evidence will serve to support or discredit his or her testimony. Through this analysis, as judges of the facts, you weigh the testimony of each witness and then determine the weight to be given to it. Through the process, you may accept all of it, a portion of it, or none of it. Now, the burden of proving the identity of the person who committed the crimes is upon the state. For you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant is the person who committed the crime or crimes. The defendant, Paul Caneiro, as a part of his general denial of guilt, contends that the state has not presented sufficient, reliable evidence to establish beyond a reasonable doubt that he is the person who committed the alleged offenses. The defendant has neither the burden nor the duty to show that a crime, if committed, was committed by someone else, or to prove the identity of that other person. You must determine, therefore, not only whether the state has proven each and every element of the offenses charged beyond a reasonable doubt, but also whether the state has proven beyond a reasonable doubt that this defendant is the person who committed it. Now we're going to see who's paying attention. See if you've heard this before. As a general rule, witnesses can only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give their opinion as to any matter in which they are versed, which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determine the facts in this case. In this case, the state and defendant both called experts. Danielle Reed, Christine Schlenker, Christopher Simkovac, Teresa Nizizan Brule. In the field of forensic DNA analysis, Allison Lane in the field of forensic serology, biological stain identification, Detective Deborah Bassender in the field of forensic accounting, Dr. Lauren Thoma and Dr. Alex Zhang in the field of forensic pathology, Judith Link in the field of gunshot residue, Detective Sergeant Christopher Clayton in the field of firearm and tool mark identification, Detective Joseph Cardoma in the fields of bloodstain pattern analysis and fire investigation or origin and cause determinations. Michael Abraham in the field of electrical and electromechanical matters, including cause and origin of fires and explosives. John Lightbody in the field of fire investigation, origin and cause determination. Lazaro Cardenas in the field of trust and estate law, and Carl Reich in the field of forensic DNA analysis. Just think that's how many times I've read that charge to you in the past. You are not bound by such expert opinion, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications.
I love that just it's slid in there very, very carefully, but basically there is the Mythbusters call to the universe. I reject your reality and insert my own. So I love that you can take the experts or you can tell them to go pound sand. DNA isn't real. Oh, ma'am. Again, no eyebrows. And now no lips. You're like the weirdest Cabbage Patch ever. Okay, I need to put myself on mute or I'll just be mean.
And credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether from all of the evidence in the case, you find that those facts are true. You may in fact determine from the evidence in the case that the facts that form the basis of the opinion are true, not true, or true in only part. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. You and you alone are the sole fact finders in this case. You must be persuaded solely by the evidence presented at trial when determining whether the state has satisfied its burden. As the sole judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be afforded to their testimony to determine whether the state has proven beyond a reasonable doubt all elements of the crimes charged. The ultimate determination of whether or not the state has proven defendant's guilt beyond a reasonable doubt is to be made by you alone. There is for your consideration recorded and unrecorded oral statements allegedly made by the defendant. It is your function to determine whether the statements made let me say that again. It is your function to determine whether the statements were actually made by the defendant, and if made, whether the statements or any portions of them are credible. In considering whether or not an unrecorded oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider the evidence with caution based on the generally recognized risk of misunderstanding by the hearer or the ability of the hearer to recall accurately the words used by the defendant. Aside from the risk of fabrication, verbal admissions can be unreliable because experience shows that they are frequently misunderstood, imperfectly remembered, and inadvertently made. The specific words used and the ability to remember them are important to the correct understanding of any oral communication because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. In this case, it is alleged that the defendant made unrecorded statements to Fire Marshal Craig Flanagan, Detective Brian Weisbrot, and Detective Christopher Brady. You also heard statements recorded by the body-worn cameras of Patrolman David Marino, Patrolman Brendan Bernard, and Patrolman Charles Wankowski. In considering whether these statements are credible, you should take into consideration the circumstances and facts as to how the statements were made, as well as all other evidence in this case relating to this issue. If, after consideration of all these factors, you determine the statements were not actually made, or the statements are not credible, then you must disregard them completely. If you find the statements were made and that part or all of the statements are credible, you must give what weight you think appropriate to the portion of the statements you find to be truthful and credible. You were also presented with a video during the trial. It's always within the special function of the jury to determine the facts. This includes whether it...
People were also saying, because I was kind of going through different law and crime, court TV, even though they're all being bought out by, or court TV is being bought out by law and crime, but people were saying, now, I will admit that I have sort of divorced myself or not been in the US politics as much, but Laura Loomer, angry, bitter people yelling about how their side is good and everyone else is stupid, it's just not my cup of tea. Once in a while, if there's a funny angle to it, but I have just found that with the limited amount of time that I have to watch, streams for fun, it's not my go-to anymore. Before I before I was content creating, I probably watched a bit too much, but now that when I have, a chance to watch something, I don't wanna do that.
Excuse me, this includes what is or is not depicted on a video and what significance, if any, that it has. In this case, Detective Ryan Mahoney, Brian Weisbrot, and Lieutenant Patrick Petruzillo narrated a video for you. Detective Mahoney, Captain Weisbrot, and Lieutenant Petruzillo are not eyewitnesses to the events depicted on the video and did not observe the events as they happened. Rather, the witnesses' testimony is based on their viewing of the video after the incident occurred. This testimony was permitted only for the limited purpose of, 1, providing context for the video, such as the location of the recorded events and or the location and or angle of the camera that made the recording, and or 2, explaining the length of the video, whether redactions were made, and or when it will be fast forwarded, and or 3, focusing your attention to a specific individual action and or circumstance allegedly depicted in the video. Just let me make sure it's on number 4. Mind you, okay. It says number 5 on my sheet, but it's actually number 4. Sorry, I'll fix that. For the limited purpose of drawing the juror's attention to certain parts of or objects depicted in the video, and to therefore aid in your review of the evidence. You may not consider Detective Mahoney, Captain Weisbrot, and Lieutenant Petruzillo's narration or other comments on the video for any other purpose. The narrating witness's testimony may assist you in deciding what the video shows. However, you are not bound by the narrating witness's testimony, and you may reject any narration testimony. You should consider each opinion and give it the weight to which you deem it is entitled, whether it be great, slight, or none at all. Ultimately, it is up to you and you alone to decide for yourself what the video shows and what it does not show. It is also up to you to determine how much weight to give the video evidence. In other words, it is the role of the jury to decide the significance and import of the video, as well as anything shown in the video. I also remind you that the ultimate determination of whether the state has proven defendant's guilt beyond reasonable doubt is to be made by you alone. Now, during the trial, you heard 3 phone calls that were recorded during the time frame of November 2018 to February 2019, which indicate that as of those dates, the defendant, Paul Caneiro, was arrested and incarcerated. The fact that the defendant was arrested and incarcerated for any period of time should not enter into your discussions or deliberations in any manner at any time. Arrest, indictment, and incarceration are not evidence of guilt, but rather a part of the pretrial procedure that occurs prior to the matter coming before you to determine whether the defendant is guilty or not guilty of the crimes charged. As I remind you, the defendant is presumed innocent, and the burden of proving each element of the charges beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. Only you, as members of the jury, will decide whether the state has met his burden. You have heard testimony that the defendant, Paul Caneiro, lawfully owned a collection of various firearms, fire accessories, and training items within his home at 27 Tilton Drive in Ocean Township. This evidence is being offered for a very limited purpose. You may consider it insofar as it may relate to the defendant's ability to carry out these alleged crimes, i.e., that he had the means and or opportunity to commit the charged offenses. Or, if you do not find that this evidence to be relevant, you may then disregard it. You may not use this evidence for any other purpose, such as to conclude that the defendant has a bad character or that he has a propensity to commit violent crimes. You may not use this evidence to convict the defendant simply because he owned weapons or because you may personally disapprove of individuals who lawfully possess firearms. While the defendant lawfully possesses these firearms, training items, and related accessories in his home, the state alleges that the defendant unlawfully possessed a handgun outside of his home, specifically at 15 Willowbrook in Colts Neck, New Jersey. The state further alleges that the defendant possessed this handgun with the purpose to use it unlawfully against others. As you have heard, the state bears the burden of proving each element of the crimes charged beyond a reasonable doubt. You, as members of the jury, will decide whether the state has met that burden. You have heard testimony from, excuse me, from prosecutors Decker and Wallace, Lieutenant Petrozzillo, and Captain Weisbrot speaking to a witness about the case at some point prior to coming to testify.
It's reading. Ma'am, I know you're probably my age. Didn't you participate in the Book It Club? You know, back when Pizza Huts were still alive and a beautiful place? I know you probably got your own personal pan pizza. Come on, you can do it. Find your place.
Testify at trial. The law permits prosecutors and detectives to speak to a witness about a case before the witness testifies, and it permits assistant prosecutors and detectives to review with the witness the questions that may be asked at trial, including questions that may be asked on cross-examination. Speaking to a witness about their testimony is a normal part of preparing for trial. It is not improper as long as there is no suggestion made to the witness that the witness depart from the truth. You have also heard testimony that a witness read or reviewed certain materials pertaining to this case before the witness testified at trial. The law permits a witness to review certain materials if there is no suggestion made to the fact that the witness departed from the truth. The defendant contends that there is evidence before you indicating that some other person than him that may have committed the crime or crimes, and the evidence raises a reasonable doubt with respect to the defendant's guilt. In this regard, I charge you that a defendant in a criminal case has the right to rely on evidence produced at trial that has a rational tendency to raise a reasonable doubt with respect to his own guilt. I have previously charged you regarding the state's burden of proof, which never shifts to the defendant. The defendant does not have to produce evidence that proves the guilt of another, but may rely on evidence that creates a reasonable doubt. In other words, there is no requirement that this evidence proves or raises a strong probability that someone other than the defendant committed the crime. You must decide whether the state has proven the defendant's guilt beyond a reasonable doubt, not whether the other person or persons may have committed the crimes. As you know, Paul Caneiro elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Paul Caneiro did not testify. That fact should never enter into your deliberations or discussions at any time or in any manner. Paul Caneiro is entitled to for the jury to consider all the evidence presented at trial. He is presumed innocent whether or not he chooses to testify. All right, ladies and gentlemen, we've been going at this for about 55 minutes. Can you stand up for me for a minute? I just want you to stretch out. Yourself a minute or two. We're about to go into part 3.
Are we looking at a trilogy? Are we looking at a quadrilogy? Are we looking at anything written by George R.R. Martin? I need to know when this ends. I do much better if I know that even if there's 15 parts, if I know there is an end, I'm better. It's these open-ended, what is going on? No, 3 of what? You know, as I'm objectively looking at things that bother me in my behavior, JKD Buck, as your son would say, Homer, it's you.
Take your time. You don't have to sit down because of me whenever you're ready. Okay. The third part deals with the criminal code, which will give you the elements of the charges for each one of the crimes in the indictment. I'm going to be providing you with a lot of information. Don't panic. Just listen to what I have to say. I promise you by the time that this is over, I will make sure that it is easy for you. Right now, I just want you to listen to what I'm telling you. Try to digest it as much as you can. But again, just wait until the end, and then we'll talk about it. Okay? Now I'll instruct you on the third part.
We've only just begun. I don't know why I just heard the Carpenters, but why do I feel like I feel like this was a false ending. Like, isn't there that part in Exodus where they think that they found the promised land, but it was kind of a trick because they got a little full of themselves? And then they had to wander the desert for another 20 years. I just feel like we're in that part where we got a little full of ourselves. And I hate that idea.
of the instructions on the portions of the criminal code that you must apply to the facts you find in determining whether the state has proven it beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute read together with the indictment identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. In addition, you will have the opportunity to consider other offenses besides those charged in the indictment. This is what we call a lesser offense crime or offense of a lesser degree that is included within the charges brought in the indictment. I will give you instructions about how to consider this lesser offense shortly. There are multiple charges in the indictment. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant is guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based on the law as I will give it to you. Now I'm going to talk to you about a lesser included offense. The law requires that the court instruct the jury with respect to a possible lesser included offense or offenses, even if they are not contained in the indictment. Here, there is a lesser included offense of arson relative to the aggravated arson charged against the defendant Paul Caneiro in count 8 of the indictment. Just because the court is instructing you concerning this offense does not mean that the court has an opinion one way or another about whether the defendant committed this or any other offenses. You should consider these offenses along with those for which furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the weapon used, the location, the number and nature of the wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro are among circumstances to be considered. Although the state must prove that the defendant acted either purposely or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offenses beyond a reasonable doubt, the defendant must be found guilty of the offense regardless of the defendant's motive or lack of motive. If the state, however, has proved a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether the defendant is guilty of the crime charged. A homicide or a killing with a deadly weapon, such as a firearm and or a knife, would permit you to...
Jason, we did a poll. Let me go back and see, because I know so 1 to 2 hours, 32%, 2 to 3 hours, 32%. Tomorrow, which would be, I think, 3 to 4 hours because of where we're probably going to land. I think you're right. I think somewhere around there.
to draw an inference that the defendant's purpose was to take life or cause serious bodily injury resulting in death. A deadly weapon is any firearm or other weapon, device, instrument, material, or substance which in the manner it was used or is intended to be used is known to be capable of producing death or serious bodily injury. In your deliberations, you may consider the weapon used and the manner and circumstances of the killings. If you are satisfied beyond a reasonable doubt that the defendant shot and killed Keith Caneiro with a firearm, you may draw an inference from the weapon used, that is a firearm, and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant shot and or stabbed and killed Jennifer Caneiro with a firearm and or a knife, you may draw an inference from the weapon used that the firearm and or the knife and the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you're satisfied beyond a reasonable doubt that the defendant shot and or stabbed and killed Jesse Caneiro with a firearm and or a knife, you may draw an inference from the weapon used that is the firearm and or knife, and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant stabbed and killed Sophia Caneiro with a knife, you may draw an inference from the weapon used, that is the knife, and from the manner and the circumstances of the killing as to the defendant's purpose or knowledge. The second element that the state must prove beyond a reasonable doubt is the defendant caused, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death or serious bodily injury resulting in death. As I previously advised you, to convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury that resulted in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it's highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful serious bodily injury murder, the state must prove beyond a reasonable doubt that it is the defendant's conscious object to cause serious bodily injury that then resulted in the victim's death, and that the defendant knew that the injury created a substantial risk of death, and that it is highly probable that the death would result. In order for you to find the defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. Whether the killing is committed purposely or knowingly, causing death or serious bodily injury resulting in death must be within the design or contemplation of the defendant. All jurors do not need to agree unanimously concerning which form of murder is present, so long as all believe that it was one form of murder or another. However, for a defendant to be guilty of murder, all jurors must agree.
One way or another, it's a red rum or a homicide. One way or another, it's, well, life without parole. I don't know. Nancy Streisand, or was it Fonda? Look, I don't remember who you were, but One Way or Another was a good song.
That the defendant either purposely or knowingly caused the death or serious bodily injury resulting in the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro.
Boosh, I defy you. I defy you to have anything left in your brain. You are lucky I am still able to have semi-coherent speech. We had a 4-hour closing from the defense. From the defense. She hurt us, Boosh. We're still traumatized.
If after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant either purposely or knowingly caused, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death or serious bodily injury resulting in death, then your verdict must be guilty as to that specific count of murder. If, however, after all of the consideration of the evidence, you find that the state has failed to prove any element of the offenses beyond a reasonable doubt, then your verdict must be not guilty as to that specific count of murder. As to purposeful or knowing murder counts, the state alleges that the defendant acted by his own conduct in causing the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro. If you unanimously find that the defendant either purposely or knowingly caused the death of or serious bodily injury resulting in the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro, you must also decide whether the state has proven beyond a reasonable doubt that the defendant committed the homicidal act by his own
JKD Buck, I don't know, but apparently Genlennial women or millennial women of a certain age are all becoming Murphy Brown. I thought we all agreed that shoulder pads were a terrible idea. But no, the early 90s are coming back. You've been warned. You've been warned.
Conduct. A finding of own conduct does not require a specific finding that the defendant's actions standing alone caused the victim's death. The relevant inquiry is whether the defendant actively and directly participated in the homicidal act or acts. The critical elements are whether the defendant acted and the immediacy of his conduct to the victim's demise. In other words, the defendant must be the direct and immediate cause of death to satisfy the own conduct element. Now, I want to give you the verdict sheet for a minute.
The theory was it was called a power suit. So, in theory, it was to mimic a more male silhouette, stronger shoulders, uh, giving a more masculine look. Now, when you're trying to pair a masculine look with, again, anyone, I dare you to watch Working Girl, with 27 shades of fuchsia, and press on nails along with hair so big, I don't understand how that message was supposed to be, but in the theory, that was the, I think, general idea behind it. Now, why anyone thought it worked, I don't know. Because I don't know if you know this, but being a bit, averse to certain sensations, God invented scissors, and those sons of bitches are only holding on by 2 little threads. You can cut those things out. You do realize.
What I'm asking you to do is not to flip through it, just we're going to start right from the top for a minute. If you find the defendant committed the crime of purposeful knowing murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he acted by his own conduct, you must answer yes to the own conduct question on the verdict sheet. You'll then be asked questions as it relates to the count in the indictment. So if you're looking at that right now, you see as to count 1, we're talking about Keith Caneiro. You'll answer the question, guilty or not guilty, as it relates to the crime of murder. The sub-questions underneath, the first question you're going to answer is whether...
No, she paid $300 for it at a vintage boutique, where they resell vintage clothing. You know this heifer does not spend anything less than $300 on something, and you know it. And hey, if it's within her means, then more power to her. I just could not in my life. Now, ask me the same thing about Lord of the Rings Legos, and I will explain to you how getting the entire, set, is a good investment. And is price really an object when you think about happiness? So I'm not saying we all don't have our things because, as I said, I would try to justify the Lord of the Rings sets, all of them. So, we're all a bit of a hypocrite.
It's done by his own conduct. You're going to answer that yes or no. Remember, you only get to own conduct if you found him guilty of the murder of Keith Caneiro. The next question would be yes or no, whether it was by his own conduct. If the answer to that is yes, then we're going to go to the other questions that you see there, which would then be 1B. And this is where we are. Okay, so 1A is that it's by his own conduct. And now let's go to 1B. The question is, did the defendant, Paul Caneiro, commit the murder in expectation of the receipt of anything of pecuniary value? If you unanimously agree that the state has proven beyond a reasonable doubt that the defendant did commit the murder in expectation of the receipt of anything of pecuniary value, then you must answer yes on the expectation of the receipt of a pecuniary value question. If the defendant, if you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt that he committed the murder in expectation of the receipt of anything of value, then you must answer no to the expectation of the receipt of pecuniary value question. You'll still go, no matter what you answer for 1B, if you're now into these subsections, you're going to answer each one of them. You're going to answer B.
Okay, hey, lawyerologists, geniuses, Kurtz that are writing these instructions. I know that you are probably, and look, I'm a vocabulary person. I hear a word like pecuniary and I can't help but want to look it up and then use it in a sentence a bunch of times because it does sound slightly phallic, not gonna lie. That being said, I don't know who the hell's writing these instructions, but pecuniary might not be something that everyone knows. So maybe fiduciary could be a word, still sufficiently, 8th grade to high school level, verbiage, but something that's a little bit more ubiquitous. If you watch even, Jeopardy.
C, and D, no matter what, if you've answered that he's guilty to count one and that he did it by his own conduct. Does that make sense, everybody?
Yes.
Okay, so let's go to C, no matter what you say on B. If you find that the defendant committed the crime of purposeful or knowing murder and that he committed the crime by his own conduct, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial.
Yeah, but I'm just throwing out there that if you're me and you know what it really means, but you also know what it sounds like it means. It sounds like of or having to do with penology. It does sound like something that, you get and you have to go to the health department for. Like, "Y'all, I have a case of pecuniary." And they're like, "Oh, is that a penicillin thing?" Like, "God, um, bless you, I'll light a candle for you." So,
Punishment or confinement for another offense committed by the defendant, then you must answer yes to the committed for the purpose of escaping question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense committed by the defendant, then you must answer no on that part of the verdict sheet. As to count 1D, if you
or it kinda sounds like something you put on a charcuterie board, like it's a cut of meat from a deli that, you know, it's just ham, but, it's in Target and they wanna charge you $18 because, whatever reason. So it sounds like something like, "Would you like to try the pecuniary? It's on the charcuterie board under the live, laugh, love sign." Or my version of hell.
find unanimously that the defendant acted by his own conduct, you will need to determine whether the defendant committed the murder of Keith Caneiro while the defendant was engaged in the commission of or an attempt to commit or flight after committing or attempting to commit murder. If you find that the defendant committed the crime of purposeful knowing murder while the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder while engaged in the commission of or an attempt to commit or flight after committing or attempting to commit murder, then you must answer yes.
Yes, it means of or having the shape of a peninsula. So it might not actually be a peninsula. That's actually what I call Mr. Moe's. Okay, again, these things that I forget that most people don't want the truth, because he was asking me about his hairline, and I said, "No, it's okay, your peninsula is still the same." And he said, "What are you talking about?" And I said, "Well, it's you know, kind of you've got inlets here and here, and then you've got a surface, so 3 sides of the front of your hair is covered by not hair, so you have a hair peninsula." Oddly enough, that is not what he wanted to hear. So when I say that I've grown leaps and bounds on learning when I'm supposed to say things, not so much, not so much.
To while in the course of a murder question on the verdict sheet. If you find that the defendant committed the crime of knowing and purposeful murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder while engaged in the commission of or an attempt to commit or flight after committing or attempting to commit murder, then you must answer no on the while in the course of murder question on the verdict sheet. So that analysis that we just talked about, you're going to do that same exact analysis for Jennifer. If you find her defendant guilty of the murder of Jennifer Caneiro, and it is by his own conduct, you're going to answer those subsection questions. When we get to Jesse and the Sophia, Jesse is count 3, you're going to answer another question. Let's go to that one for a second. So if we're looking at that, all of us should be on page, I think it's on page 5, but let me just confirm. Yeah, see, 4 deals with JC, which is Jesse Caneiro. So if you go to page 5, which is where E is located, that's still the other question that we're going to ask for this one. As to Jesse and Sophia Caneiro, you will have additional questions. If you find unanimously that the defendant acted by his own conduct, you will also need to determine whether per count 3, Jesse Caneiro, per count 4, Sophia Caneiro, were less than 14 years old. If you find that per count 3, Jesse Caneiro, per count 4, Sophia Caneiro, were less than 14 years old, and you unanimously agree that the state has proven beyond a reasonable doubt that the defendant committed the murder per count 3, Jesse, per count 4, Sophia, while they were less than 14 years old, then you would answer yes to the victim was less than 14 years old question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt.
I think he is of the personality type that will seek vengeance. So again, I'm an armchair psychologist, but he has a vengeful spirit. He doesn't see things as, "Oh, well, maybe I don't own all of this business, so maybe Keith is, tired of me stealing stuff." He sees things as personal slights to him. So I would imagine that he has, and you don't think that he wouldn't be very upset at Corey, who he probably blames for not getting, and I'm guessing his wife and children not being entitled to any bit of the trust after all that went on. I'm sure he thinks that, oh, well, I might not be entitled to it, but my girls will be, and I can, of course, control them into giving me stuff. But Corey, No, especially after he's been accusing him of red rum. Thank you, Thor.
That the defendant committed the murder while each one of them, Jesse and Sophia, were under the age of 14, then you would answer no. So if you find that the state didn't prove that they were under the age of 14, then you'd be answering no to that question. And that's E for each one of count 3 and for count 4. Does everyone see that on the verdict sheet? Yes. Okay, great. Now we're going to take all your verdict sheets back for a minute. Please just pass them down. That'd be great. Okay, the next charge is the next 2 charges are for felony murder. Defendant is charged in count 5 of the indictment with the felony murder of Jesse Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of felony murder by causing the death of Jesse Caneiro while engaged in the commission of or an attempt to commit or in the flight after committing.
So, sorry, the cats are quite upset that they have been in my room all day because I think that the door is nearly done or completely done. But I believe that the trust went to Corey, and then while the Canero brothers' parents were alive, the father helped kind of finish up the businesses, get maybe square one sold to Terminex. So I don't know. And again, I hope Corey gets to live a life free of all this drama and can go back and try to heal as much as he can with all that's gone on. So I don't know any more than that.
Or attempting to commit the crime of arson. The defendant is charged in count 6 of the indictment with the felony murder of Sophia Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of felony murder by causing the death of Sophia Caneiro while engaged in the commission of or an attempt to commit and or flight after committing or attempting to commit the crime of arson. The state contends that on November 20th, 2018, while the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson, he stabbed and killed Jesse Caneiro and or Sophia Caneiro. The section of the statute applicable to this case reads in pertinent part as follows. Criminal homicide constitutes murder when it is committed when the actor is engaged in the commission of or attempt to commit or flight after committing or attempting to commit arson, and in the course of such crime or the immediately flight therefrom causes the death of a person other than one of the participants. Generally, it does not matter that the act which caused death was committed recklessly or unintentionally or accidentally. The perpetrator is as guilty of felony murder as he would be if he had purposely or knowingly committed the act which caused death. For you to find the defendant guilty of felony murder, the state is required to prove beyond a reasonable doubt from all the evidence in the case, all the essential elements of the crimes charged. Accordingly, before you can find the defendant guilty of the felony murder of Jesse Caneiro in count 5 or Sophia Caneiro in count 6, the state must prove beyond a reasonable doubt that 1, on or about November 20th, 2018, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson as noted as the lesser included offense of count 7, that the death of per count 5 Jesse Caneiro, per count 6 Sophia Caneiro was caused by the defendant, and number 3, that the death of per count 5 Jesse Caneiro per count 6, Sophia Caneiro, was caused at some time within the course of the commission of that crime, including its aftermath of flight and concealment efforts. The first element requires the state to prove beyond a reasonable doubt that the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson. In order for you to find the defendant guilty of arson, the state is required to prove each of the following elements beyond a reasonable doubt: that the defendant purposely started a fire at 15 Willowbrook Road in Colts Neck, New Jersey. 2, that the act of starting the fire recklessly placed, per count 5, Jesse Caneiro, per count 6, Sophia Caneiro, in danger of death or bodily injury. You cannot find the defendant guilty of felony murder unless you first find him guilty beyond a reasonable doubt of having committed the crime of arson. And again, arson, as we're talking about here, is
They are public defenders. He did, for a period of time, have paid attorneys, but they are public defenders, which is why I am shocked that they are so bad, because usually, again, public defenders, in my experience, have been very good at, understanding court procedure, what is going to be accepted, what's not, what is, a good argument for this judge, what's not a good argument, how to get in evidence, how not to be discovery violations. So I did wonder if these were their first trials, but no, they've been practicing law for multiple years in theory-ish.
That's what's charged in the indictment that I'm going to talk to you about in a minute, which is aggravated arson. This is the lesser offense of arson of what we're talking about. So for you to find him guilty of this charge, he has to be guilty of arson first. Everybody get that? All right. The second and third elements require the state to establish that per count 5, Jesse Caneiro, per count 6, Sophia Caneiro's death was caused by the defendant and was caused during the commission of or attempt to commit or flight after committing or attempting to commit crime of arson. To meet its burden of proof as to the second and third elements pursuant to count 5 and 6, the state must prove beyond a reasonable doubt the following. 1, that but for the defendant's conduct in the commission of or attempt to commit or flight after committing or attempting to commit arson, Jesse Caneiro and or Sophia Caneiro would not have died. In other words, that Jesse Caneiro and or Sophia Caneiro's death would not have occurred without the commission of the arson. Number 2, Jesse Caneiro and or Sophia Caneiro's death was a probable consequence of the commission of or attempt to commit or flight after committing or attempting to commit arson. For the death to be the probable consequence of the arson, the death must not have been too remote or too accidental in its occurrence or too independent on another's volitional acts to have a just bearing on the defendant's liability or the gravity of his offense. In other words, you must decide that if the state has proven beyond a reasonable doubt that under all of the circumstances, the death did not occur in such an unexpected or unusual manner that it would be unjust to find the defendant responsible for the death. In conclusion, if you find the state has proven beyond a reasonable doubt that 1, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempt to commit the crime of arson, 2, that Jesse and or Sophia's death was caused by the defendant, and 3, that the death of the person was caused at some time within the course of the commission of the crime, including its aftermath or flight and concealment efforts, then you must find the defendant guilty of felony murder. On the other hand, if you find that the state has failed to prove beyond a reasonable doubt any one or more of those elements beyond a reasonable doubt, then you must find the defendant not guilty of felony murder. If you find that the state has failed to prove beyond a reasonable doubt that the defendant caused the death of Jesse Caneiro and or Sophia Caneiro, then the defendant should be found not guilty of all charged homicide offenses, including these two victims. If, however, you find beyond a reasonable doubt that the defendant did cause the death of Jesse Caneiro and or Sophia Caneiro, but that the state has failed to prove beyond a reasonable doubt that the defendant was at the time engaged in the course of the commission of or attempt to commit or flight after committing or attempting to commit arson, then you still can consider the separate crime of murder. All right, counts 7 and 8. They both deal with aggravated arson. Count 7 of the indictment charged the defendant with aggravated arson in violation of 2C 17-1A. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Jesse Caneiro and or Sophia Caneiro in danger of death or bodily injury, and or with the purpose of destroying a building and or structure of another, to wit, 15 Willowbrook Road, Colts Neck, New Jersey, belonging to Keith and or Jennifer Caneiro. As to count 8, again, an aggravated arson charge. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the township of Ocean, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Susan Caneiro and or Marissa Caneiro and or Caitlin Caneiro in danger of death or bodily injury, to wit 27 Tilton Drive, Ocean, New Jersey, belonging to Paul Caneiro and or Susan Caneiro. The section of the statute applicable to this case reads in pertinent.
Okay, is it wrong that it kind of gives me a special little thrill in my heart that it probably chafes the Caneiro family's ass? Well, I mean Paul Caneiro's family, the daughters and the wife, that some of Paul's charges are in connection with them. I'm just saying it perversely, in the best kind of schadenfreude, just kind of makes my day. I know it says more about me and my emotional maturity than it does about them, and I find I'm okay with that.
Part as follows. A person is guilty of aggravated arson if he starts a fire or causes an explosion, whether on his own property or another's. 1, thereby purposely or knowingly placing another person in danger of death or bodily injury, and or 2, with the purpose of destroying a building or structure of another. For the defendant to be found guilty of aggravated arson, the state must prove the following elements beyond a reasonable doubt. 1, that the defendant purposely started a fire per count 7 at 15 Willowbrook Road in Colts Neck, per count 8 on his own property at 27 Tilton Drive in the township of Ocean. 2, that the act of starting the fire, A, purposely or knowingly placed, per count 7, Jesse or Sophia Caneiro, per count 8, Susan or Marissa or Caitlin Caneiro, in danger of death or or bodily injury, not serious bodily injury. And or 3, was done with the purpose of destroying a building or structure of another, to wit, per count 7, 15 Willowbrook Road in Colts Neck, per count 8, on his own property of 27 Tilton Drive in the township of Ocean. So you're looking at 2 different ways the state can prove aggravated arson. It's either by way of causing danger of death or bodily injury to the individuals within the home, or for the purpose of destroying a building or structure of another, or in count 8, dealing with Paul Caneiro's own structure or house, okay? The first element that the state must prove beyond a reasonable doubt is 1, that the defendant purposely started a fire at or near premises known as per count 7, 15 Willowbrook Road in Colts Neck, and count 8, his own property at 27 Tilton Drive in Ocean. A person acts purposely with respect to the nature of his conduct or a result thereof, if it is his conscious object to engage in conduct of that nature or cause such a result. A person acts purposely with respect to attendant circumstances if he is aware of the existence of such circumstances or believes or hopes they exist. With purpose, design, with design, or equivalent terms have the same meaning. Purpose is a condition of the mind that cannot be seen and can only be determined by inferences drawn from the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular purpose. It is within the power of the jury to find that the proof of purpose has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. It is not necessary that any significant damage be done. It's only necessary that a fire be started for one or more of the purposes to be described. The lack of success of the perpetrator is immaterial. 2, the second element the state must prove beyond a reasonable doubt is that at the time the defendant started the fires, he purposely or knowingly placed, per count 7, Jesse and Sophia, per count 8, Susan, Marissa, or Caitlin in danger of death or bodily injury. His purpose was to destroy 15 Willowbrook in count 7 or 27 Tilton in count 8. Bodily injury means physical pain, illness, or other impairment of physical condition. I have already defined the term purposely for you. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of such a nature or that of such circumstances. Let me start over. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or he is aware of a high probability of their existence. A person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowledge is a condition of the mind that cannot be seen and can only be determined by inferences drawn by the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular knowledge. It is within the power of the jury to find the proof of knowledge that has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. Destroy means to demolish and or render useless and or render completely ineffective for its intended use. If you find that the state has proven all the elements of aggravated arson beyond a reasonable doubt, then you must find him guilty of aggravated arson. On the other hand, if you find that the state has failed to prove all the elements of the aggravated arson beyond a reasonable doubt, then you must find the defendant not guilty. Now I'm going to talk to you about the lesser included offense of aggravated arson, which is arson. A lesser included offense to aggravated arson is in the indictment is arson. Can I see the attorneys for a second?
Is there a lesser, like, pretend arson, not so good arson, inefficient arson? Because, I could be persuaded that he committed attempt to arson at his house and full arson at Keith's house. I'd be open to that interpretation.
Why don't you guys take a stretch for a second? don't think I could touch the ceiling if I jumped.
Probably.
Let's see.
Definitely here for your entertainment. I just want to.
At least the camera.
I'm going to say with absolute certainty, I can't do it.
Camera. Yeah.
I love this judge.
I think I can get the camera. And then, no my luck, I'll knock it off.
Right? 6 inches maybe. At least.
It has failed to meet one of the elements of aggravated arson in count 7 and/or 8 beyond a reasonable doubt. Here's the elements of arson. A person is guilty of arson if he purposely causes a fire or it's getting good now. A person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own.
He wanted something, Jim. So I'm mother when youngest most feral would like something, and then I'm mom or bruh when he forgets to remember his manners.
Property or another's. 1, thereby recklessly placing another person in danger of death or bodily injury. In order for the defendant to be found guilty of arson, the state must prove beyond a reasonable doubt the following elements. Number 1, that the defendant purposely started the fire on either 15 Willowbrook Drive and or on his own property of 27 Tilton Drive in Ocean Township. And that 2, that the act of starting the fire recklessly placed at 15 Willowbrook, it would be Keith Caneiro and Jennifer Caneiro. At 27 Tilton, it would be Susan Caneiro, Marissa Caneiro, or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It's only necessary that a fire be started purposely. The lack of success of the perpetrator is immaterial. I've already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was the defendant's purpose or conscious object to start a fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed at 15 Willowbrook, it would be Keith Caneiro, it is, all right, I got to start over. I apologize. When we're talking about the arsons, as you recall, we were talking about, give me a second.
I don't know if he left the room or he just lost his place.
Person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own property or another's. Another. 1, thereby recklessly placing another person in danger of death or bodily injury. In order to find the defendant to be guilty of arson, the state must prove the following elements beyond a reasonable doubt: that the defendant purposely started a fire at 15 Willowbrook Road, Colts Neck, New Jersey, and or 27 Tilton Drive in the Township of Ocean, New Jersey, and that the act of starting the fire recklessly placed at 15 Willowbrook Road, Jennifer Caneiro and or Keith Caneiro, and at 27 Tilton, Susan Caneiro or Marissa Caneiro or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It is only necessary that a fire be started on purpose. The lack of success of the perpetrator is immaterial. I've already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was defendant's purpose or conscious object to start the fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed Keith Caneiro and or Jennifer Caneiro at 15 Willowbrook Road, or Susan Caneiro or Marissa Caneiro or Caitlin Caneiro at 27 Tilton in danger of death or bodily injury. Bodily injury means physical pain, illness, or any other impairment of physical condition. I've already defined the term purposely for you. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. If the state has failed to prove any of the elements as I've described to you beyond a reasonable doubt, you must find the defendant not guilty of arson. If you find the state has proven every element of the crimes charged beyond a reasonable doubt, then you would find them guilty of arson. So what's the difference between aggravated arson and arson? The act of purposely starting the fire is the same for aggravated arson and arson. The difference becomes in the second portion, whether he acted purposely or knowingly.
Jim, that's because they've already gone over the charges of murder, and there is an aggravator additional that makes, if this were in a different place, it would be capital or first degree murder, because of them being children and the children dying because of the arson. So they died while he was already doing a crime. So they have mentioned the kids. These are different charges for the adults. Since it's an aggravating factor, these are different classifications of crimes if they're against an adult and if they're against a child. So they've already gone over the ones for a child. So now they're working on the ones for the adults.
Putting these individuals, the victims, in the position of either in danger of either death or bodily injury. Purposely or knowingly for aggravated arson, recklessly for arson. So it's just the mental state that changes between aggravated arson and arson. Does that make sense? Okay. My confusion was just dealing with, I want to make sure that I was clear with the victims' names. Okay, we're going to count 9. Count 9 of the indictment charges the defendant Paul Caneiro with the crime of possession of a firearm with the purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a firearm with the purpose to use it unlawfully against the person of another by possessing a handgun with the purpose to use it against Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. Any person who has in his possession any firearm with a purpose to use it unlawfully against the person or property of another is guilty of a crime. For you to find the defendant guilty on this charge, the state has the burden of proving beyond a reasonable doubt each of the following four elements of this crime. 1, Exhibit S-193 is a firearm. 2, defendant possessed the firearm. 3, defendant possessed the firearm with the purpose to use it against another person or a person of another. 4, defendant's purpose was to use the firearm unlawfully. The first element that the state must prove beyond a reasonable doubt is that S-193 is a firearm. A firearm means any handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectile ball, slug, pellet, missile, or bullet, or any gas, vapor, or other noxious thing by means of a cartridge or shell, or by the action of an explosive, or the igniting of flammable or explosive substances. It shall also include, without limitation, any firearm which is in the nature of an air gun, spring gun, or pistol, or other weapon of such a nature in which the propelling force is a spring, elastic band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure a person. The second element that the state must prove beyond a reasonable doubt is the defendant possessed the firearm. To possess an item under the law, one must have a knowing, intentional control of that item accompanied by a knowledge of its character. So a person who possesses an item such as a handgun must know or be aware that he possesses it, and he must know that it is that he possesses or controls that it is a handgun. Possession cannot merely be a passing control, fleeting or uncertain in its nature. In other words, to possess an item, one must knowingly procure or receive an item or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. The state must prove beyond a reasonable doubt that a possessor acted knowingly in possessing the item. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that the conduct is of that nature, or that such circumstances exist, or he is aware of the high probability of their existence. A person acts knowingly as to the result of his conduct if he is aware that it is practically certain that the conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. As I told you in the past, knowledge is a condition of the mind. It can't be seen. It can be determined only from inferences, from conduct, words, or acts. Therefore, it's not necessary for the state to produce a witness to testify that a particular defendant stated, for example, that he acted with knowledge when he had control over a particular thing. It is within your power to find the proof of knowledge has been furnished beyond a reasonable doubt by inference, which may arise from the nature of the acts and the surrounding circumstances. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had, in fact, at some point prior to his arrest, had control over it. Possession means a conscious, knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is. That is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the firearm was to use it against the person of another. Purpose is a condition of the mind which cannot be seen and can only be determined by inferences from conduct, words, or acts. In determining the defendant's purpose in possessing the firearm, you may consider that a person acts purposely with respect to the nature of his conduct or a result of his conduct if it is in the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. The defendant's purpose or conscious objective to use the firearm against another person or the property of another may be found to exist at any time he has the possession of the object and need not have been the defendant's original intent in possessing the object. The fourth element that the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the firearm in a manner that was prohibited by our law. I've already defined purpose for you. This element requires that you find the state has proven beyond a reasonable doubt that the defendant possessed a firearm with a conscious objective, design or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. In this case, the state contends that the defendant's unlawful purpose in possessing the firearm was to use it unlawfully against the person of Keith Caneiro or Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. So that's the only thing you're looking at for his unlawful purpose, what I've just described to you. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of the defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the firearm. If you find the state has failed to prove any of the elements of the crime beyond a reasonable doubt, your verdict must be not guilty. On the other hand, if you're satisfied that the state has proven each and every element of the crime charged beyond a reasonable doubt, your verdict must be guilty. The 11th count of the indictment charges the defendant with the crime of possession of a weapon for unlawful purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro on November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a weapon for unlawful purpose by possessing a knife with the purpose to use it unlawfully against the person of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. A person who has in his possession any weapon with the purpose to use it unlawfully against the person or property of another is guilty of a crime. In order for you to find the defendant guilty of this charge, the state has the burden of proving beyond a reasonable doubt each of the following four elements. Number one, Exhibit S-313 is a weapon. 2, defendant possessed the weapon. 3, defendant possessed the weapon with the purpose to use it against the person or property of another.
It's not the funnest stuff, but I think so. There are a lot of different charges, and again, that kind of does make this appeal proof because there are so many different things that the jury has to find true that, even if, say, the appellate court says, okay, well, upon appeal and in the light most favorable to the state, we agree that maybe they didn't prove arson for his family, for his particular family members. Okay. Well, he's still charged with a bajillion and 12 other things, so he's never getting effing out. So yeah, it's tedious, it's pedantic, it's boring, but it's it's necessary, unfortunately.
4, defendant's purpose was to use the weapon unlawfully. The first element the state must prove beyond a reasonable doubt is that S-313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. It is possible that a knife is not normally considered a weapon. If, however, the state established beyond a reasonable doubt that the object is capable of being used to inflict serious bodily injury or death, it may be considered a weapon. The second element that the state must prove beyond a reasonable doubt is that the defendant knowingly possessed the knife. I've already defined possession for you. I've already defined knowingly for you. And I've already told you that knowledge is a condition of the mind and it only can be determined based on inferences, conduct, words, or acts. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had in fact at some time prior to his arrest had control over it. Possession means a conscious knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is, that is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the object was to use it as a weapon against Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. As I told you in the past, purpose is a condition of mind that cannot be determined, that can't be seen. It can only be determined by inference from words, conduct, or acts. In determining the defendant's purpose in possessing the weapon, you may consider that a person act purposely with respect to the nature of the conduct or a result of his conduct if it is the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. Defendant's purpose or conscious object to use the weapon against the person or property of another may be found to exist at any time he is in possession of the object and need not have been the defendant's original purpose in possessing the object. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the weapon in a manner that is prohibited by law. I've defined purpose for you already. This element requires that you find that the state has proven beyond a reasonable doubt that the defendant possessed a weapon with a conscious objective, design, or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. An object may be possessed for an innocent or for a lawful purpose. However, an innocent or lawful purpose or possession of a weapon may change and become unlawful and a violation of this statute. The state need not prove the defendant's original purpose in possessing the weapon. The state need only prove beyond a reasonable doubt that the defendant's purpose at a specified time he possessed it was to use it unlawfully against the person or property of another. In this case, the state contends the defendant's unlawful purpose in possessing the knife was to commit serious bodily harm, resulting in the death of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the surrounding circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the weapon. If you are satisfied beyond a reasonable doubt that the state has proven each of the elements that I've defined to you beyond a reasonable doubt, then you should find him guilty. However, if you find that the state has failed to prove any of those elements beyond a reasonable doubt, then you would find him not guilty. Count 12 of the indictment charges the defendant with unlawful possession of a weapon. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of unlawful possession of a weapon by knowingly possessing a knife under circumstances not manifestly appropriate for such lawful uses as it may have. That section of our statute provides in pertinent part, any person who knowingly has in his possession any other weapon under circumstances not manifestly appropriate for such lawful uses as it may have is guilty of a crime.
To convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt. 1, S313 is a weapon. Count 2, the defendant possessed a weapon knowingly. Count 3, defendant possessed a weapon under circumstances not manifestly appropriate for a lawful use. The first element that the state must prove beyond a reasonable doubt is that S313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. The second element the state must prove beyond a reasonable doubt is that the weapon was knowingly possessed by the defendant at a time and place alleged. Here, the state alleges that the defendant possessed the weapon on or about November 20th, 2018 in Colts Neck, New Jersey. I've already defined knowingly for you. Knowledge is a condition of mind. It can't be seen. I've already explained how to analyze this mental state. Thus, the person must know or be aware that he possessed the item, here a knife, and then he must know what it is that he possesses or controls. In other words, that it is a knife. This possession cannot merely be a passing control that is fleeting or uncertain in its nature. In other words, to possess within the meaning of the law, the defendant must knowingly procure or receive the item possessed or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chooses to do so. When we speak of possession, we mean a conscious knowing possession. The law recognizes two kinds of possession, actual and constructive. A person is in actual possession of a particular article or thing when he knows what it is. That is, he has knowledge of its character and knowingly has it on his person at a given time. A person who, with knowledge of its character, knowingly has physical control over a thing at a given time is in actual possession of it. The law recognizes that possession may be sole or joint. If one person alone has actual or constructive possession of a thing, possession is sole. The third element that the state must prove beyond a reasonable doubt is that the defendant possessed S313 and or another knife under circumstances not manifestly appropriate for such lawful uses as it may have. It is not necessary for the state to prove that the defendant formed an intent to use S313 or any other knife as a weapon. It is, however, necessary for the state to prove that it was possessed under such circumstances that a reasonable person would recognize that it was likely to be used as a weapon. In other words, under circumstances where it posed a likely threat of harm to others. You may consider factors such as the surrounding circumstances, size, shape, and condition of the object, the nature of its concealment, the time, place, and actions of the defendant when it was found in his possession to determine whether the object was manifestly appropriate for its lawful use. If the state has proven each element beyond a reasonable doubt, each of the elements of this particular charge beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if the state has failed to prove any one of those three elements beyond a reasonable doubt, then you must find him not guilty. Count 13, theft. Count 13 of the indictment charges defendant with theft by unlawful taking or disposition of movable property. The indictment reads as follows. Paul Caneiro, bless you. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th through 2018, in or about various municipalities in the county of Monmouth, including but not limited to the Township of Ocean and or the Township of Colts Neck, County of Monmouth, did commit the crime of theft by unlawfully taking or exercising unlawful control over movable property of another, to wit, money valued at $75,000 or more belonging to Keith Caneiro or Jennifer Caneiro, Jessica Caneiro, and or Sophia Caneiro, with the purpose to deprive the owner thereof. The statute upon which the indictment is based provides in pertinent part that a person is guilty of theft if he unlawfully takes or exercises unlawful control over movable property of another with purpose to deprive him thereof. The state must prove each of the following elements beyond a reasonable doubt. 1, that the defendant knowingly took or unlawfully exercised control over movable property. 2, that the movable property was property of another. 3, that the defendant's purpose was to deprive the other person of the movable property. The first element, which the state must prove beyond a reasonable doubt, is that the defendant knowingly took or exercised unlawful control over movable property. Property means anything of value, including tangible and intangible personal property. Movable property means property with a location of which can be changed, including things growing on, affixed to, or found in land or documents, although the rights represented thereby have no physical location. For comparison purposes, immovable property is all other property. Defendant must knowingly take or exercise unlawful control over movable property. I've already defined knowingly for you. Knowledge is a condition of the mind. It can't be seen. I've already explained how to analyze that mental state. In this case, the state alleges that the movable property taken or over which control was unlawfully exercised is the following: money valued at $75,000 or more. It should be noted that the definition of movable property is broad, including the kind of property which has no real location. The state need not prove that the property was carried out of the place in which it was kept, but only that it was moved or taken from its original location, or that defendant exercised unlawful control over it, whether he was able to actually move or remove the property. The second element the state must prove beyond a reasonable doubt is that the movable property is property of another. Property of another includes property in which any person other than the defendant has an interest, which the defendant is not privileged to infringe, regardless of the fact that the defendant also has an interest in the property, and regardless of the fact that the other person might be precluded from civil recovery because the property was used in an unlawful transaction or is subject to forfeiture or as contraband. Property in the possession of the actor shall not be deemed property of another who has only a security interest therein, even if legal title is the creditor pursuant to a conditional sales contract or other security agreement. The term property of another is broadly defined to include services and intangibles, anything of value. Anything of value is defined as any direct or indirect gain or advantage to any person. The third element, which the state must prove beyond a reasonable doubt, is that the defendant's purpose was to deprive the other person of the movable property. For the purpose of this statute, the term deprive specifically means, one, to withhold or cause to be withheld property of another permanently, or for so extended a period as to provide a substantial portion of its economic value, or with purpose to restore only upon payment of reward or other compensation, or two, to dispose or cause disposal of the property so as to make it unlikely that the owner will recover it. I've already defined purposely for you. It's a condition of the mind, can't be seen, and I've told you how to analyze it. If you find that the state has proven all of three elements beyond a reasonable doubt, then you must find the defendant guilty of that charge. If you find the state has failed to prove any of those elements beyond a reasonable doubt, then you must find him not guilty of that charge. Since the value of the property, the movable property, determines the degree or severity of the crime, the state must prove its value beyond a reasonable doubt. If you find defendant guilty, then you must indicate the value of the property. The state must prove the amount or value of the property beyond a reasonable doubt. So if you find the defendant guilty of the offense, then you must decide where it fits in the amount of money beyond a reasonable doubt. You kind of heard a little bit about that today. So you're going to answer the question, and I'll show you on the verdict sheet. If it's $75,000 or more, then you would check that one off. All 12 must agree. If you don't find that, but you find it's between $500,000 and $75,000, then, and all 12 of you agree, then you would check off that number. And then we continue to go on. The third one is at least $200, but less than $500. And then the last one is just less than $200. And again, we're going to go over this on the verdict sheet. If you find that the amounts involved were taken in thefts committed pursuant to one scheme or course of conduct, the amounts may be added together to form a single total amount, whether stolen from one person or from several people. So again, you can add money together. If you find differing dates that money were taken, then you can add that money together in your overall determination of where it fits. Again, assuming that you actually found guilty of theft. If you don't find the three elements that would be guilty of theft, then we're not even talking about the amount of money that was involved. Okay. Count 14, charges defendant with misapplication of entrusted property. The indictment reads as follows. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th, 2018, in or about various municipalities in the county of Monmouth, including but not limiting to the Township of Ocean and or the Township of Colts Neck, County of Monmouth, did commit the crime of misapplication of entrusted property by purposely or knowingly applying or disposing of property that was entrusted to them as a fiduciary, to wit, money valued at $78,180 belonging to Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro upon agreement in a manner which they knew was unlawful or involved substantial risk of loss or detriment to the owner. The pertinent part of the statute on which the indictment is based reads as follows. A person commits a crime if he applies or disposes of property that has been entrusted to him as a fiduciary in a manner which he knows is unlawful and involves substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted, whether or not the actor has derived a pecuniary benefit. The state must prove the following 6 elements of the crime beyond a reasonable doubt. 1, defendant knowingly applied or disposed of property. 2, the property at issue was entrusted to defendant as a fiduciary. 3, defendant's application or disposition of the property was unlawful. 4, defendant's application or disposition involved substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. 5, defendant knew that his conduct was unlawful. And 6, defendant knew that his conduct involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. First,
Or as the defense would say, a little bit of theft-ish.
element the state must prove beyond a reasonable doubt is that the defendant knowingly applied or disposed of property. Here, the state asserts that the property was money valued at $78,180. The term property means anything of value, even though it may be impossible to identify particular property as belonging to the victim at the time. Defendant allegedly misapplied the property because the victim's property may have been mixed with or joined with other property. Defendant must have applied or disposed of the property knowingly. I've already defined knowingly for you. I've also already told you that it's a condition of the mind and how you go about evaluating that element. The second element the state must prove beyond a reasonable doubt is that the property at issue was entrusted to defendant as a fiduciary. A fiduciary includes a trustee, guardian, executor, administrator, receiver, and any other person carrying a fiduciary function on behalf of a corporation or other organization, which is itself a fiduciary. A fiduciary relationship arises between two persons when one person is under a duty to act for or give advice for the benefit of another on matters which within the scope of their relationship. The fiduciary's obligations to the dependent party include a duty of loyalty and a duty to exercise reasonable skill and care. The third element the state must prove beyond a reasonable doubt is that the defendant's application or disposition of the property was unlawful. That is, he applied or disposed of the property in a manner contrary to the responsibility as a fiduciary. In this case, the state asserts that the defendant's responsibility was to manage and administer the trust's assets in accordance with the terms of the trust agreement while acting in the best interest of the beneficiaries. As As I have already explained, the state bears the burden of proving defendant's guilt beyond a reasonable doubt as to every element of the crime. The state's burden is not reduced or shifted to the defendant because he may have violated a fiduciary duty. The fiduciary duty of care is relevant to determine defendant's state of mind because it may have placed defendant on notice as to what was expected of him when he became the custodian of the property. A violation of a fiduciary duty in and of itself is insufficient as a matter of law to sustain a finding of criminal culpability. However, together with any other evidence in the case, you may consider defendant's breach of his fiduciary duty as evidence of the defendant's state of mind. The more egregious the violation, the more likely defendant acted knowingly. For example, an extended pattern of conduct displaying an utter disregard for his fiduciary duty would have more probative value than an isolated incident of bad record keeping or accounting. Fourth, the state must prove beyond a reasonable doubt that the defendant's application or disposition of the property involved substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. Fifth, the state must prove beyond a reasonable doubt that the defendant knew that his conduct was unlawful. I've already defined knowingly for you. Sixth, the state must prove beyond a reasonable doubt that the defendant knew that his application or disposition of the property involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. A substantial risk is one that is of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the defendant's situation. In other words, the state must prove beyond a reasonable doubt that the defendant knew that it was very likely that his treatment of the property would create a risk of loss or detriment to the owner or person whose benefit the property was entrusted, and that defendant went ahead anyway, where a reasonable doubt would not. I've already defined knowingly for you. It is not necessary for the state to prove the defendant himself derived the benefit during his application or disposition of the property. If the state has proven each of the 6 elements of the crimes charged beyond a reasonable doubt, then you must find defendant guilty of misapplication of entrusted property. On the other hand, if the state has failed to prove any element beyond a reasonable doubt, then you must find him not guilty. If you find the defendant not guilty, your consideration of the misapplication of entrusted property charge should end here. However, if you found that he is guilty beyond a reasonable doubt, then you must proceed to make 2 additional factual findings. Specifically, you must indicate whether the defendant derived a benefit from his misapplication of entrusted property, and if so, the benefit he derived. First, you must determine whether the state has proven beyond a reasonable doubt that the defendant derived a benefit as a result of his misapplication of entrusted property. Benefit means a gain or advantage or anything regarded by the beneficiary as a gain or advantage, including but not limited to a pecuniary benefit or a benefit to any person or entity in in whose welfare he is interested. Please indicate whether the state has proven that the defendant derived a benefit from his alleged misapplication beyond a reasonable doubt by marking yes or no on your verdict sheet. And then if you have determined both that the defendant is guilty of a misapplication of entrusted property and indicated yes that the defendant did derive a pecuniary benefit from the misapplication, then you must go on to determine the amount of that pecuniary benefit. Specifically, you should indicate on the verdict sheet if the benefit that the defendant derived has a value of $75,000 or more, or exceeds 500 but less than 75,000, or is at least 200 but doesn't exceed 500, or is less than 200. The benefit derived includes the value of all funds or property misapplied by the defendant. That is, the value of the property misapplied is not simply the value of its use.
Yes, yes. The gallery's pretty much cleared out. So I do wonder, again, maybe at the end of this, he'll kind of give us a clearer idea of typically how long he'll let juries deliberate on the day, because that's kind of the one thing that I struggle with, at least the first day of jury or verdict watch. Uh, Typically, I don't know how this judge behaves or, how late they'll let them stay. So I don't know what we're looking at. So hopefully he's clear with that. And then can you imagine sitting through all of this only to be made an alternate? I think I would lose my ever loving ish.
During the period in which defendant exercised control over the property. For example, if a defendant applies or disposes of $5,000, but later reimburses the victim, the value of the benefit derived is the full $5,000. It is not merely the amount of interest that a bank might have charged for the use of the $5,000 loan during the period in which the defendant made use of the money. Similarly, if a defendant applies or disposes of $5,000, but reimburses the victim for all but $200 of the amount, the benefit derived is still $5,000, the entire amount involved. In calculating the benefit derived, you must include, but are not limited to, the amount of any tax avoided, evaded, unpaid, improperly retained, or improperly disposed of. All right, count 15 and 16. These are the last two. The
Oh,
defendant
thank you,
is charged
Jesus.
in count 15 of the indictment with the offense of hindering his own apprehension or prosecution, in that he is alleged to have, with the purpose to hinder his own.
Okay, I kind of feel like we can give Paul this. I mean, who wouldn't try to hinder their own apprehension? I mean, of all the things he did, or evidence tampering.
Detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which may have aided in his discovery or apprehension in the lodging of a charge against him. The indictment reads as follows. Paul Caneiro, on or about November 20, 2018, in or about the township of Colts Neck, or in the township of Ocean, county of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder or his own detention, apprehension, investigation, prosecution, conviction, or punishment of the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or the lodging of a charge against him. As to count 16, defendant is charged in count 16 of the indictment with the offense of hindering his own apprehension or prosecution, in that he alleged to have, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him.
I know it doesn't
The
sound
indictment reads as follows.
right.
Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which might have aided in his discovery or apprehension or in the lodging of a charge against him. These charges are based upon a statute which provides that a person commits an offense if with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for an offense he suppresses by way of concealment or destruction any evidence of the crime which might aid in the discovery or apprehension of such person or in the lodging of charges against him, or prevents or obstructs by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him. For you to find the defendant guilty, the state must prove each of the essential elements of the offenses beyond a reasonable doubt. Those elements are: 1, that the defendant knew that he could, might be charged with murder and or theft and or misapplication of entrusted property. 2, that the defendant suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or in the lodging of a charge against him, and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. And 3, that the defendant acted with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment. The first element the state must prove beyond a reasonable doubt is that the defendant must have known that he could / might be charged or was liable to be charged with murder and or theft and or misapplication of entrusted property. I've already defined knowingly for you, and I've told you that it's a condition of the mind and it has to be determined based upon inferences from the defendant's conduct, words, or act. The second element the state must prove beyond a reasonable doubt is that on November 20th, 2018, that the defendant suppressed by way of concealment or destruction any evidence of the crime and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. The third element that the state must prove beyond a reasonable doubt is that the defendant acted with the purpose of hindering the detention, apprehension, investigation, prosecution, conviction, or punishment for murder and or theft and or misapplication of entrusted property. I've defined purposely for you. If after considering all of the evidence, you conclude that the state has proven each of these elements beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you find the state has failed to prove any of these elements beyond a reasonable doubt, then you must find him not guilty. We're very close. We're on to part 4. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon, let me say that again. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in light of your own knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I've said before, an exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked into evidence can be given to you. Available to you in the jury room will be the discs of audio and or video evidence. Please note that these discs may only be played in the courtroom and not by you, the jurors, in the jury room. If you as jurors want to see or hear some part of those items of evidence, you have to send out a note and let me know. Even though there's a TV in there, you're not going to be able to use that. You're going to have to come out here. We're all going to be present and we're going to watch it with you. Very shortly, you're going to go into the jury room to start deliberations. I remind you that during deliberations, and in fact, any time that you are in the jury room, you must keep any cell phone, pager, or other communication device that you possess off. You are to apply the law as I have instructed you to the facts as you find them to be, for the purpose of arriving a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous.
What about a beeper?
How about you be a beaver?
You don't even know what a beeper is.
Yes, I do.
Mm-hmm.
As to each charge. This means
Apparently, a beeper is an animal.
all of you must agree on guilt or innocent, or guilt or not guilty on a particular charge. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration
Don't
of the
encourage
evidence
this.
with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it was erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are partisans. You are not partisans. You are judges of the facts. You may return to each crime charge a verdict of either not guilty or guilty. Your verdict, whatever it may be, must be unanimous, meaning all 12 deliberating jurors must agree. To assist you in reporting a verdict, you're going to have a verdict form. We can give them out right now. You had it before. We're going to give it now, and now you get to keep it. As we are giving that out right now, as brutal as that was for you to listen to me, was as brutal as it was for me to say it with my voice. But here's what I want to tell you. I just gave you the law verbally. Understanding how difficult that would be for all of you to remember all of that, each one of you will have your own binder that will have the charge as I just read it to you. So you're going to have that. Now you're going to say to yourself, are you kidding me? You just made me sit here and listen to that, even though I could have just read it myself. That's not the way
Again, this could have been an email or an emailed PowerPoint.
it works, ladies and gentlemen. I have to know, Mr. Caneiro has to know, all the attorneys have to know that you actually read every single page. That's why we read it together, all together in the same room, and it's on the record. And you should listen to my charge as I told it to you. It's not going to be different from this. I may have cut some things a little short because I had already told you once or twice, but you're going to have the actual charge as that I just verbally gave to you to be able to use as a reference, to be able to go back and listen for the elements when you're talking about a particular charge. Now, you have the verdict sheet in front of you. As you can see, and we talked about counts 1 through 4 already. I'm not going to go through this entire document, but I'm going to give you a flavor so that you understand. Okay. So when you look at that document right now, it does not give you the elements of all the crimes charged. All it gives you is basically an answer key for you to log in what your answers are for a particular charge. That's the only thing that we're using it for. It will also help you and guide you to make sure you answer any and all questions that are being asked of you. We've talked about questions 1 through 4, but you'll see with each question underneath, there will be a bold, for example, to tell you, do I have to go on to a subsection, or do I go on to the next count? So for example, as we talked about in count 1, how do you find as to count 1 of the indictment charging the defendant Paul Caneiro with the murder of Keith Caneiro? It's either guilty or not guilty. And then you see underneath, if you find him guilty, then you're to answer 1A. If you find him not guilty, then you would just go to count 2. 1A deals with doing it by his own conduct, as we talked about before. If you answer yes to 1A, then you go to B and C. If you answer no to 1A, well, then you would not answer B and C, which is exactly the bolded parts underneath. And again, it goes to 1B and C. C is located on the next, D is located on the next page. And then you see, if you've gone through question 1, A, B, C, and D, then you see underneath it says go to count 2. Same thing applies for each count. Let's go to, for a minute, let's go to count.
Yeah, I really do like that he's walking through this and how you look at the form. I don't think that that the other judge have done this. Now, StreamYard is being a butt monkey as far as comments, so I am seeing and trying to respond to them, at least in the chat.
7. 7 discusses aggravated arson. How do you find as to count 7 of the indictment charging the defendant Paul Caneiro with aggravated arson as to the structure of 15 Willowbrook Road? That is, if you answer that he's guilty of that charge, then you're not answering 7A. 7A only deals with arson. So it's the lesser included offense. If you found him not guilty of count 7, then you would go down to 7A and answer that question because you found him not guilty of aggravated arson. So then you would consider the crime of arson. Does that make sense? And that's the same for 7 and 8. Let's go to count 13 for a minute, which is on page 14 of the verdict sheet. All right. How do you find as to the theft charge? If you find him guilty, then the 13A is the amount that you find, and that should be included at that particular point. Was it more than 75,000? If not, 500, but less than 75,000, you would check there. If it exceeds 200, but less than 500, you would check there. And if then none of those apply, then the last one would be is less than $200. But remember, different from murder, when I said you can agree to one form of murder of either killing and or serious bodily injury resulting in murder, it doesn't matter as long as all 12 of you agree. When it comes to this, when you're talking about those ranges, all 12 of you have to agree to the same range. It can't be one different from the other. Okay? Count 14 deals with the misapplication of entrusted property. Again, if you find him not guilty of that charge, you would not answer A and B of 14. If you find him guilty of it, then you would go down to 14A. If you say yes to 14A, then you go to 14B. But if not, if you say no, then you would not go to 14B. Then the last two charges are just guilty or not guilty. So that is the verdict sheet. Now, if during your deliberations you have a question or you feel that you need further assistance or instructions from me or wish to have certain testimony read or played back, which is either audio or video or some type of exhibit that you needed to see that maybe you don't have, write your question or request on a sheet of paper and give it to the sheriff's officer who will be standing at the jury room door, who in turn will give it to me. The court officer will be sworn to perform certain duties, such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You are not to discuss with or ask the officer about any trial matters or procedures. Please be aware the officer is also instructed not to initiate communications with you or enter the deliberation room without your consent, except to communicate on behalf of administrative matters such as breaks, meals, the end of the day, telling you that you're going to go home, come back the next day. If an officer must enter the deliberation room, The officer will knock first, and once he's done with completing whatever he was asked to do by me, then he would leave the room, and then you could start your deliberations again. But do not deliberate when he is in the room. He or she is in the room. Once I receive your question or request, I'll go over it with the lawyers, and I'll get you an answer as soon as possible. Please be patient. If we have to get something electronically, you got to give us a minute to put it together so we can put it on the screen so you can come out and see it. Please, if you're in the middle of a debate on a particular issue, do not tell me that you are, Judge, we're 6-6, we're 10-2 on this issue. Can you just help us out a little bit? I don't want to know where you are in your process. The only thing I need to know is either you got a question and I'm going to answer it for you, or you got a verdict and then we know it's unanimous. That's the only time. Okay. Now I've come to my end of my charge. Let me just speak to the attorneys for a second. I'm going to take a second.
Yeah, and honestly, I wonder how long the jury's going to wanna stay today. This has been a long day. Do they want to stay and get it done? Or do they because I wouldn't have thought that we would have gotten a verdict the same evening as Uvalde, but we did. So it'll be interesting to see if the jury is just done and they will, plug on through as late as they possibly can, or if they want to start fresh in the morning. Or maybe he's trying to figure out whether how late everyone can stay. Very good point, Kelly Rager. I'm very glad he was thorough, so there will not be any room for appeals for judiciary mistakes. Although it took a very long time, he was being very thorough. Good for the judge. Yes. It is 4:28 over here. Like I said, I'll probably go to 5:30, probably 5:30. Um, unless the judge is very clear on how late he'll let them stay. Because that's kind of going to depend that'll kind of shape my answer to what I'm doing.
Ladies, want the truth. Can we have our way that we do our alternates? We bring that in.
Mom, is the Olympics still happening?
Yes.
It's a lot to do.
That's a luge.
Dude.
It's a sled.
Oh my gosh, that's
No, you're good. We know where you are. Get ready.
Knew it.
Put it. I want absolutely no responsibility at all. So what Anna's doing is, so that you're aware, is that it just says juror 1 through 16 on some cards. And what we'll do is we spin it.
Oh,
We put a
yeah.
hand in there and we come up with one.
Then the other one, the face first.
2026, we're in.
Works.
We have just bonus question.
Okay, go ahead.
Juror number 16.
There's number 16. Okay, keep going.
Juror number 15.
15. This thing spins well.
Trimming from the top. So they get. Fortunately, that thing messed up.
11.
Okay, one more.
Eight.
8.
That's
Okay. So jurors number 8, 11, 15, and 16 will be my alternates. So right now, just hang out for a second. And we'll talk about that role in a minute.
Can and will
What I
do.
want to do is right now is I'm going to swear in my officers.
Fine.
If there's new officers tomorrow morning, then I'll swear in new officers. But I'm going to ask for the officer in the back and also the officer in the front. If you don't mind, could you just raise your right hand for me? Do you solemnly swear or affirm that you will do your best to keep every
Okay, how many people, when they hear, do you solemnly swear? I am up to no good. I mean, damn it.
person sworn on this jury together in a private place, and that you will not allow any person to speak to them nor speak to them yourself except by order of the court, and except to ask them if they have agreed on a verdict until they have so agreed?
I did.
Thank you. All right. All right. So next part. I want to give you an idea for the people that will be in the jury room for a minute. I just want to tell you the items that you will have, because you won't have certain items in there. For example, we don't give you the guns in there, or we don't give you the bullets in there, and we definitely don't give you both of them at the same time.
Your Honor, how do you want a unanimous vote? I feel like you're hindering us. You're hamstringing us, Your Honor.
So if you want to see the weapons, any one of the weapons involved, you would have to ask me. You have to write a note saying, can we see S whatever? And then we'll give it to you. And if you don't know the S number, we'll take care of it. So let me just tell you what you do have in evidence. S1, which was the photo book with all its subsections, you have that. You will have S2.1, which is a photo from the Caneiro family. You'll have S7. I'm not going to read them all, but I guess I have to. Text messages that you'll have from November 20th, 2018. S8. Well, if you're going to physically have them, I don't think I have to read every one. You'll have S8, S10, S11, S12. These are all records, so you'll physically have all of them. S17, 18, 19, 26,
Only 300 to go.
28, 29.1 through 29.10, 30.1 through 30.19, 33.1, 34.1, 35.1, 40, A and B, 42, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 61, A and B, 62, 63, 64, 65, 65, 66 A and B, 74 A, B, C, D, and D.1. Now, did 70, I should go back. So 66 is the Waze camera from the kitchen area and the office area. You'll have a disc of that. If you want to see it, you got to come in here and we got to watch it. 74, which is the body worn camera of Patrolman Marino. If you want that, you got to let us know. It's in evidence. We'll bring you out here to play it. S76, A, B, C, and D. That's the Patrolman Wankowski's body worn camera. Again, if you want to see it, come on out. 78, same thing. Patrolman Bernard's body worn camera. Come on out and we'll show it to you. Then you'll have S93, S94. S96 is the 911 call from Boris. That's 96B. 99 is the CD of Catherine Lucchese's 911 call. 101 is the DVD of the sergeant from Colts Neck, his MVR. If you want to see that, you can come out. We bring you out. 102, same thing. It's Patrolman Stephen DeCaesar's Colts Neck, his MVR, and if you want to see the gas can at S155, we're not going to put a gas can in there. If you need it, well, we can give it to you. You okay?
Yeah.
Okay, we're almost there.
Good. Liquid adjustments.
The gas can. Then you'll have 156, 157, 158, 159, 160, 162. It's the automatic knife. You saw that. If you need to see that, you have to tell us. We'll come out here and you can look at it. Same thing. Well, you'll have 163, 164, 166, 165. You'll have 168, 169, 170, 171. You'll have 172. You'll have 173. 7, but you can have items from the autopsy. You'll have all those. That's 2. For when you start deliberations, we normally finish the day somewhere between 4:30 and 5. But because it's been an extremely long day for all of you, and a ton of information, and out of respect for all of you guys now, what I'm going to do is I'm going to send you home for the day. However, this is how it's going to work tomorrow morning. Tomorrow morning, as soon as all 12 deliberating jurors are here, if it's 8:02 and you're all here, Amor is going to bring you up. She's going to put you in that room. In that deliberation room will be all of the evidence that we just discussed. So you're going to go in there and you get started. There's no more wait. In that room will also be 12 binders that will have all of the charges laid out for you. So you'll have your verdict sheet. You'll have your binder. It'll all be in one little binder for you, so everybody can open them up and talk together as a team to figure it out. And you'll get started. My 4 deliberating jurors, you will be taken to another room very close to this room. Why do I do that? I'm not going to leave you downstairs. Here's why. If something happens to one of our 12, we take the 4 numbers, when we bring you back, and we then put it right through this lovely machine again. We pick one out of the 4, random, and then that one would go in to replace one of the 12 that couldn't continue. But we need 12 to be able to decide. understand if you're not, for example, if somebody doesn't come in tomorrow or whatever that is, then, for example, if you're one of the 12 deliberating jurors, I'm replacing you at this point. And we're not, at this point in time, we don't slow down. Here's what I'll tell you. Tomorrow, you have as much time as you need. You have all day if you want it. Probably, if for some reason at 5 o'clock or so tomorrow, if we're not done, fine, no problem. What I do is I bring you back on Tuesday. I don't bring you back Monday because Monday's the holiday. So I don't want you to stress about time. You have as much time as you need to be able to do whatever that you need to do. So with that being said, though, you have everything, but you can't start yet. Tomorrow morning, you'll start first thing, and you go as long as that you need. So thank you it was a long day. It's a long 2 days for you all. And I'm beyond thankful. And I'm watching you, and you guys have been wonderful. Probably the best jury that I've seen, and I've been doing this for a long time. So I'm beyond thankful for everything that you've done, your attentiveness, and we'll get this going tomorrow morning. So we'll bring you downstairs. You're gone for the day. Leave your verdict sheets exactly where they are. We'll take care of that. We'll pick them up from you. You don't have to try to do anything with that. We'll get you out of here, and then we'll see you tomorrow morning. So as soon as we have all 12, we're bringing you up. You will not see any of the attorneys tomorrow morning. You will not see the defendant tomorrow morning. Then at this point in time, it's all about you. If you're in the room, you do your thing. The only time you're seeing any one of us is that if for some reason you have a question or if you have a verdict. Okay? All right. Thank you all.
Judge, very quickly, if we could just approach.
Okay. Sorry. If anybody has to go in there, go ahead, just in case you have to use the bathroom or something.
Okay, so crap. I was like, I've been on so long, I don't remember. So I don't know what holiday. I feel dumb for not knowing. Maybe President's Day? Wasn't Martin Luther King Day a week ago or so? There we go. I was like, the holiday where we buy mattresses and refrigerators. So you guys, our plan is that we will have the weekly roundup with me and Shizzy, and then we will start Verdict Watch at 10. And what I plan to do is we are going to watch the judge dressing down this attorney after she tried to do sneaky stuff. And basically go back to any witnesses we want to rewatch, the canine officer, anything like that. I don't foresee this going to Tuesday, but the moment I say that, it could be very possible that it is. So honestly, I have a feeling that if we start at 10, we'll get through the dressing down just barely before verdict time. I think it'll take about 2 hours to get through all the paperwork, but we'll just play it by ear. So there you go. Have a lovely, lovely evening. Let me see who I can send you guys to. Garfield and friends. All righty. Oh, it looks like there might be ring footage. Again, I am not going to try to say this gentleman's name because good Lord, I stink out loud, but he covers a lot of live events, so I'm sending you over there. Send him some love, but it does look like there might be interesting updates from the Nancy Guthrie thing. So there you are. I will see you guys in a little bit, tomorrow morning. Probably not a little bit, probably tomorrow morning. But thank you guys so much for hanging out, and let everyone know that we will be on Verdict Watch, and we will probably. I know that the Faust case is one that we want to cover, but I'm going to be very honest with you. We are probably on Verdict Watch. If it tends to go longer, we are going to be watching funny body cam video because my brain is kind of mush. Now, I will be fully ready to take notes and try to figure out crazy on Monday, but on a Friday, after all of this testimony, y'all, I would not be paying attention. I am going to be very honest with you guys. So have a lovely, lovely rest of your day. Hope to see you on Friday and share this channel around. And I will see you guys later. Thank you so much for hanging out. Bye, you guys. Young man.
What?
Oh,